ringside seats do an ethnic cleansing.
Good evening, everyone, and welcome to another edition of the Stand on Business podcast. I am your host, Boss Man. Good evening, everybody. Hump day. God damn, it has been a busy, and I do mean a busy week in America this week since last Wednesday. Holy shit. Anyway, hi, everybody. Good to see you. All right. Hey, before we get started, put in one in the chat if you can hear me clearly. I know I can hear myself pretty clearly, but just to make sure, all right, trust but verify. So just make sure you can hear me pretty clearly. And before we get started and get into the material for tonight, it's going to be a busy week, and I'm going to fill your belly with a whole lot of law tonight. Okay. I'm going to fill your belly with a whole lot of it. All right. So before we get started tonight, hey, make sure you support the fam. All right. You can support through a Cash App to the Black Men Unfiltered Network or directly with a super chat. We accept all things. Okay. All things. All right. And if you'd be so kind to also support me directly as well. All right. You can hop on over to my channel. Okay. At the Objectivist Podcast. All right. Hop on over there. All right. And give me a like. A thumbs up, excuse me, and subscribe if you feel so inclined. All right, and come on back over here to the foxhole. All right, and sit back and grab yourself some cold drink. All right, and enjoy the show. All right. Now, with that in mind, you're gonna see this thing go back and forth. All right. For right now, we'll show the brothers some love and show the family some love. All right. So, with that in mind, let's see who is here in the foxhole for right now at the very moment. Thank you. Salute to you, sir. Appreciate you. Appreciate the confirmation. Hey, Braxton Snake Fiend, good to see you, sir. All right. Salute to you. Now, with that in mind, as more people start to trickle in, I'll go ahead and give my soliloquy for the very moment because, as I mentioned, it's been a busy week. Now, I'm just going to take a second to explain that I had a whole different show scheduled for tonight. It was actually going to be something relative to the legislature because this entire series, this State of our Union, I was going to be, going and touching, on different branches. I kind of started with talking about the executive branch, and I touched on the judiciary. But I haven't really talked about the legislature really much. And I wanted to talk about what the legislature is doing. And yes, even talk about how the Dems are even, starting to, fight back a little bit. All right. There are a few cases. I do believe it is 4. Is it 4 cases? I think it's 4 different cases that the legislature are starting to push back on relative to a particular executive order that is very, very important. But for the love of God, we cannot. I can't get to it. Reason being is because we have some bullshit happening at the very moment. Okay. We have some bullshit happening, ladies and gentlemen. And I just can't. I just can't. Okay. Ultra vires. Okay. There, Mr. President. Ultra vires. All right. If you want to pronounce it correctly in the Latin vulgar. All right. And just so we can, go ahead and get this out the way. What does it mean? And I'm going to share the screen really quick. I had something else loaded in the chamber, but I'm going to go off of what I had prepped at the very moment. What does ultra vires mean? Is a Latin phrase meaning beyond the powers. Plainly means an action by a company or its agent that exceeds the legal scope of its authority. Yes. Okay. Authority is granted by the company's own bylaws, constitution, or state statutes under which the company is subject to. Ultra vires, Mr. President, you have gone too fucking far. All right. All right. You're going beyond your constitutional powers. All right. And that was from the lawsuit that the legislature put into place. All right. So we may have to do a part 2 to this particular part 3. Yes, indeed. All right. Too damn far. All right. But I think what I'm going to be touching on today is befitting. Okay. Because there are some things that are quite concerning that I would think constitutional scholars, constitutional, holding to thine heart conservatives, I would think that you would be concerned about. Constitutionalists, I would think you'd be concerned. Wouldn't you? I would think. No? Now, before we get too far into the weeds, and I dare not bury the lead, but I'm going to perform an exercise tonight. And I hope some of you conservatives or conservative liberals, conservative Democrats, conservative Republicans, however you label yourselves conservatives, I hope you are either here live with me, or I hope you eventually watch this eventually. So I'm going to do this in a way that I'm able to either clip this. Okay. So bear with me here. Okay. So here we go. Let's do a little bit of an exercise. Shall we? Yeah, let's do it. All right. So I witnessed something very, very egregious. Okay. This particular week. And it is very, very telling and befitting of what you might see, what I like to call disinformation. Something very different from misinformation, but disinformation, a purposeful, intentional, not benign, but malignant, intentional, misleading use of information, where you purposely give misinformation. Okay, the weaponizing of misinformation. That's the difference between misinformation and disinformation. Okay, where you know something to be true and you purposely give the antithesis of it in order to fuel or to steer the narrative. Okay, that is the difference between misinformation and disinformation. Okay, all right. So, and it's this type of bullshit that happens in our society, particularly in politics, that will cause people to, how to put it, confidently vote for certain individuals. Doesn't have to be left or right. It can just be anyone in particular. And not know what they're doing, why they're doing it. Just confidently do what they're doing with the understanding that people aren't going to go and verify what you're saying because you are who you are, because you sit where you sit. There's a certain amount of faith that they have in you because you are where you are. Okay? Now, someone's strength isn't necessarily so much in what they know, but it's your ability to go and seek information and objectively look at that information and say, okay, I believe I know this thing. Now I'm going to test that knowledge. And if I am right, then I'm justified. I'm bolstered. Okay. I'm cumberbund by the information that I am finding out. I'm proven. Okay. I'm substantiated. But if I just so happen to find out that or come to some realization or some recognition that what I have found out, I've tested, just so happens to be different than what I have come to understand all this time, then my cognition is no longer going to remain dissonant. I'm going to then adjust what I understand at this point, and I'm going to adjust my perception from subjectivity to objectivity. That is the difference between cognitive dissonance and objectivity. The example of this is when you stand at a voting booth in a line and you see people being interviewed and you ask them a question. Did you see so-and-so's tweet? Did you see so-and-so's report? Did you know XYZ? And they say no. And you show it to them. You show proof. But just prior to that, they believed the opposite. And you show proof of otherwise. And in that moment, psychologically, they have a choice after being showed the exact opposite of what they have gone all this time to believe. In that moment, they have a psychological cognitive option of fight or flight. You see it every day. What's happening there is their prefrontal cortex is essentially battling itself because they know that they have just been proven wrong. And now they have to now deal with battling what they have believed versus what they have now learned. That's the difference between lying in the belief. That's why lie is in the belief and believe. See what I did there? Think about it. Chew on it for a second. That's why lie is inside the word belief versus what you have just learned. Because you don't have to believe in what you know. Got it? Cool. Now, what just happens there is that they have to now choose fight or flight. There it is, right there. Boom. Fight or flight happens right there. And now they have to choose logic or recalcitrance. Logic or idiocy. Most of them will choose idiocy because they can't wrap their head around the concept that their belief lies to them. Lies to them. Now, this is why you shouldn't put belief in humans. Got it? Now, here we go. Because it is easier or safer to believe in a lie, unfortunately, to their own detriment. Absolutely. It's safer to be lied to. It's safer to believe in the fairy tale as opposed to just hearing or understanding the potentiality of the truth. Okay. So here we go. The demonstration tonight. And I'm hoping some conservatives are here because they want to test this out to see if conservatives are going to be able to break from the pack tonight and to be able to just practice some objectivity. Here we go. Here's how this demonstration is going to work. Here's how this test is going to work. I'm going to play the clip. I'm not going to comment. I'm not going to say anything. I'm going to let it play. Right after the clip, I'm going to read what the clip is referring to. So the people in the clip are talking about a thing. They are testifying about a thing. Okay? I'm going to read that thing verbatim. We're going to read that thing verbatim together. And I want you to either comment. Well, you're going to be able to have to comment because you're not going to be able to come up here. But I want you to comment and tell me yay or nay, yes or no, if they represented what I just read correctly. Or if they practiced disinformation, or if they gave information correctly. Okay? So I'm not going to comment. I'm just going to give the thing that they're talking about right after I play the clip. Okay? We all understanding how this exercise is going to work. Okay. Ready? Here we go.
Let's hear the question from this very low-rated anchor at CB.
Thank you, President. Do you plan to ask President Bukele to help return the man who your administration says was mistakenly deported? The man who was mistakenly deported to El Salvador?
Well, let me ask Pam, would you answer that question?
Sure, President. First and foremost, he was illegally in our country. He had been illegally in our country. And in 2019, two courts, an immigration court and an appellate immigration court, ruled that he was a member of MS-13 and he was illegally in our country. Right now, it was additional paperwork had needed to be done. That's up to El Salvador if they want to return him. That's not up to us. The Supreme Court ruled, President, that if, as El Salvador wants to return him, this is international matters, foreign affairs, if they wanted to return him, we would facilitate it, meaning provide a plane.
So will you return him, President Bukele?
And you are doing a great job.
Thank you.
President Miller, wait a minute. Can you just also respond to that question? Because, it's asked by CNN, and they always ask it with a slant because they're totally slanting because they don't know what's happening. That's why nobody's watching them. But would you answer that question also, please?
Yes, gladly. So, as Pam mentioned, there's an illegal alien from El Salvador. So, with respect to you, he's a citizen of El Salvador. So, it's very arrogant even for American media to suggest that we would even tell El Salvador how to handle their own citizens as a starting point. As 2 immigration courts found that he was a member of MS-13. When President Trump declared MS-13 to be a foreign terrorist organization, that meant that he was no longer eligible under federal law, which I'm sure you know, you're very familiar with the INA, that he was no longer eligible for any form of immigration relief in the United States. So we had a deportation order that was valid, which meant that under our law, he's not even allowed to be present in the United States and had to be returned because of the foreign terrorist designation. This issue was then, by a district court judge, completely inverted, and a district court judge tried to tell the administration that they had to kidnap a citizen of El Salvador and fly him back here. That issue was raised to the Supreme Court, and the Supreme Court said the district court order was unlawful, and its main components were reversed 9-0 unanimously, stating clearly that neither Secretary of State nor the President could be compelled by anybody to forcibly retrieve a citizen of El Salvador from El Salvador, who again is a member of MS-13, which, as I'm sure you understand, rapes little girls, murders women, murders children, is engaged in the most barbaric activities in the world, and I can promise you, if he was your neighbor, you would move right away.
So you don't plan
But
to
the
ask for
Supreme
a
Court's
penalty to get him
asking
back?
to,
And
that-
what was the ruling
that your
in the
position?
Supreme Court, Steve? Was it 9-0?
Yes, it was a 9-0
In our favor.
in our favor against the district court ruling, saying that no district court has the power to compel the foreign policy function of the United States. As Pam said, the ruling solely stated that if this individual, at El Salvador's sole discretion, was sent back to our country, that we could deport him a second time.
Well,
No version of this legally ends up with him ever living here because he is a citizen of El Salvador. That is the president of El Salvador. Your questions about it, per the court, can only be directed to him.
I asked
¿Usted lo
President
liberaría,
Bukele, what is your,
Presidente
can President Bukele weigh in on this? Do you plan to return him?
Well, I'm suppose you're not suggesting that I smuggle terrorists into the United States, right?
It's
I mean,
always
how can I smuggle? How can I return him to the United States? Like I smuggle him into the United States, or what do I do? Of course, I'm not going to do it. It's like, I mean, the question is preposterous. How can I smuggle a terrorist into the United States? I don't have the power to return him to the United States.
so you could release him inside El Salvador.
Yeah, but I'm not releasing, I mean, we're not very fond of releasing terrorists into our country. I mean, we just turned the murder capital of the world into the safest country of the Western Hemisphere, and you want us to go back into the releasing criminals so we can go back to being the murder capital of the world? No, that's not going to happen.
Well, they'd love to have a criminal,
Yeah,
released into our
I mean, there's
So
a fascination.
They would love it.
Yeah.
They're sick, these are sick people. Marco, do you have something to say about
Yeah, I mean, Stephen outlined it. I don't understand what the confusion is. This individual is a citizen of El Salvador. He was illegally in the United States and was returned to his country. That's where you deport people, back to their country of origin, except for Venezuela that wasn't refusing to take people back, or places like that. I can tell you this, Mr. President, no, the foreign policy of the United States is conducted by the President of the United States, not by a court. And no court in the United States has a right to conduct the foreign policy of the United States. It's that simple. End of story.
And that's what the Supreme Court held, by the way, to Marco's point. The Supreme Court said exactly what Marco said, that no court has the authority to compel the foreign policy function of the United States. We won a case 9-0, and people like CNN are portraying it as a loss, as usual, because they want foreign terrorists in the country who kidnap women and children. But President Trump, his policy is foreign terrorists that are here illegally get expelled from the country, which, by the way, is a 90-10 issue.
Well, Mr. President, you said that if the Supreme Court said someone needed to be returned, that you would abide by that. You said that on Air Force One just a few days ago, and they said that it must be facilitated.
Why don't you just say, isn't it wonderful that we're keeping criminals out of our country? Why can't you just say that? Why do you go over and over, and that's why nobody watches you anymore. You have no credibility. Please, go ahead.
President Trump.
So here is the Supreme Court ruling that they were mentioning. On March 15, 2025, the United States removed Armando Abrego Garcia from the United States to El Salvador, where he is currently detained in the Center for Terrorism Confinement, or SCOTUS, the United States acknowledged that Abrego Garcia was subject to a withholding order forbidding his removal to El Salvador, and that the removal to El Salvador was therefore illegal. The United States represents that the removal to El Salvador was the result of an administrative error. The United States alleges, however, that Abrego Garcia has been found to be a member of the gang MS-13, a designated foreign terrorist organization, and that his return to the United States would pose a threat to the public. Abrego Garcia responds that he is not a member of MS-13 and that he has lived safely in the United States with his family for a decade and has never been charged with a crime. On Friday, April 4th, the United States District Court for District of Maryland entered an order directing the government to facilitate and effectuate the return of Abrego Garcia to the United States by no later than 11:59 p.m. on Monday, April 7th. On the morning of April 7th, the United States filed this application to vacate the district court's order. The Chief Justice entered an administrative stay and subsequently referred the application to the court. The application is granted in part and denied in part, subject to the direction of this order. Due to the administrative stay issue by the Chief Justice, the deadline imposed by the district court has now passed. To that extent, the government's emergency application is effectively granted in part, and the deadline in the challenged order is no longer effective. The rest of the court's order remains in effect, but requires clarification on remand. The order properly requires the government to facilitate Abrego Garcia's release from custody in El Salvador, and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. The intended scope for the term effectuate in the district court's order is, however, unclear and may exceed the district court's authority. The district court should clarify its directive with due regard for the deference owed to the executive branch in the conduct of foreign affairs. For its part, the government should be prepared to share what it can concerning the steps it has taken and the respect for further steps. The order heretofore entered by the Chief Justice is vacated. Statement of Justice Sotomayor, with whom Justice Kagan and Justice Jackson join. Respect to court's disposition of the application. The United States government arrested Kilmar Armando Abrego Garcia in Maryland and flew him to a terrorism confinement center in El Salvador, where he has been detained for 26 days and counting. To this day, the government has cited no basis in law for Abrego Garcia's warrantless arrest, his removal to El Salvador, or his confinement in a Salvadorian prison, nor could it. The government remains bound by an immigration judge's 2019 order expressly prohibiting Abrego Garcia's removal to El Salvador because he faced a clear probability of future persecution. Therein demonstrated in El Salvador's authorities were and would be unable or unwilling to protect him. The government has not challenged the validity of that order. Instead of hastening to correct its egregious error, the government dismissed it as an oversight. The government now requests an order from this court permitting it to leave Abrego Garcia, a husband and father without a criminal record in El Salvadorian prison for no reason recognized by the law. The only argument the government offers in support of its request that the United States court cannot grant relief once a deportee crosses the border is plainly wrong. The government's argument, moreover, implies that it could not deport and incarcerate. That it could deport and incarcerate any person, including U.S. citizens, without legal consequence, so long as it does so before a court can intervene. That view refutes itself. Because every factor governing requests for equitable relief manifestly weighs against the government, I would have declined to intervene in this litigation and denied the application in full. Nevertheless, I agree with the court's order that the proper remedy is to provide Abrego Garcia with all the process to which he would have been entitled had he not been unlawfully removed to El Salvador. That means the government must comply with its obligation to provide Abrego Garcia with due process of law, including notice and opportunity to be heard in any future proceedings. It must also comply with obligations under the Convention Against Torture, federal law governing detention and removal of immigrants continues, of course, to be binding as well. C 8 USC 1226, requiring a warrant before a non-citizen may be arrested and detained pending a decision on removal. And she goes on to cite more until I can get to a new sentence. Okay, I have to read the whole thing. Okay. Requiring the same. See also 8 CFR. In order to revoke conditional release, the government must provide adequate notice and promptly arrange an initial informal interview to afford an alien an opportunity to respond to the reasons for the revocation stated in the notification. All right, here we go. Moreover, it has been the government's own well-established policy to facilitate an alien's return to the United States if the alien's presence is necessary for continued administrative removal proceedings in cases where a non-citizen has been removed pending immigration proceedings. Okay. In the proceedings on remand, the district court should continue to ensure that the government lives up to its obligations to follow the law. Okay, now it's voting time. So, I've read the concurring or per curiam decision, and then the statement, not the dissenting statement, but the full statement. And then you've seen the video. So now, before I provide any additional commentary, what say you? Was the video informative? Correctly informative? Or was it disinformation based on the Supreme Court's no shit reading? You decide. Be right back. All right. So far, we have only one vote here. Disinformation, it seems. Hey, and by the way, salute to you there, sir. I appreciate it. Good evening, boss man. What up, chat? As a lifelong conservative and Navy vet, this is one of the fair and balanced political shows, and I get excited each week for it. So salute to you. I appreciate you, Devil Squid. Thank you, sir. I appreciate it. It's an astute compliment. All right, because it's very hard to be fair in these spaces because you want to slice and dice, what you see, right? At the same time, it's poignant to just present the facts and let people decide what's there. And the more you do that, the easier it gets. Because you start to find out that sometimes the shit's right there. And it's up to you to decide, really. So with that in mind, I appreciate it. Thank you so much. I appreciate the compliment. All right. So shout out to you, Bossman, for actually providing the facts. Let's see who actually pays attention to what's going on now. Hey, let's see. So the reason why I gave a little bit of time here for this, to come up is because once I get my screen back up here, is because Supreme Court provided what it needed to say. And that's why I had to completely redo this show. Because the Supreme Court came in and it said, this is what needs to happen. No shit, unambiguously, okay, without capitulation, and just said outright, even and don't get me wrong, guys. There's more they could have did here, but I've never seen the word alleges in a Supreme Court ruling. Ever. The fact that they couldn't say for certain that this man is or isn't part of the gang tells you that at the Supreme Court level, enough substantiation is provided for them to be able to all agree, even the conservative side, to agree based on the evidence provided by the administration. That's because the original judge back in 2019, when the Cheat on Chief was in office last time, that judge gave him protection in this country. And he established a working visa here in this country, found to be credible. Additionally, Bondi and her DOJ have no evidence. They admitted in court. These quotation marks here, administrative error, that's not sarcasm. That was a DOJ lawyer who said those things in court. That's why that DOJ lawyer is currently on administrative leave due to be fired by the Trump administration, because that lawyer stated in court that it was an administrative error and he should not have been removed. They admitted it in court. When a gang of 9 in the Supreme Court all agree, that's something you all should look at. And the silence here is deafening. Now, BMU, the reason why you didn't hear much about the last administration, at least from me, is because I came in at the tail end of the last administration. But I guess another reason why you didn't hear much about the last administration is because they wasn't doing no egregious shit such as this. Maybe. People should hear this, see this, and say, okay, in the White House, in the Oval Office, where the people there are supposed to be at the trust me, every administration is responsible for spinning, okay? There isn't an administration that has been in the Oval Office that hasn't spun something, at least since the ink press, okay? But if you are going to spin something, do a better job at spinning it. Don't spin something to where it becomes a blatant lie. That, what you heard, to me, is a blatant lie. And it's so blatant, so egregious, that it's infringing upon what is established constitutional law. So much so that you're going against the Supreme Court ruling. So why we didn't hear this much about the last administration is because when the last administration received a bad hearing or a bad ruling from the Supreme Court, You know what they did? They just went and found another law that they could then use to effectuate what they were trying to do, and they won. As opposed to saying, you know what? Fuck your 9-0. We're just going to change on live television what the hell the 9-0 said. That's what we're going to do. We're going to literally change what, and here is the nefarious part about it all. There's the low educated voters who aren't going to read this shit. They're not going to read because I love the non-educated voters. I'm Donnie Born and love the uneducated voters. I love the uneducated. There's my African American. You're absolutely correct. I have a small YouTube channel. Oh, you do? I didn't know that. And I create a content for escaping the matrix in generating financial freedom. I just present the facts. The ones who get it will absolutely 100%. I did not know you had a YouTube channel, so I will go and follow it. Absolutely. So thank you for letting me know. I had no idea. All right, so cool. Hey, so people, I don't have a lot of people watching at the very moment, so you see this, follow this brother, okay? Good to go. But he's absolutely right. Those who get it will fucking get it. And if you don't, you don't. Okay. I sat down, I think it was today or yesterday, and I sat back and I thought, you know, what's the point? What is the absolute point of me saying, well, this was yesterday. So tomorrow, what's the point of me saying tomorrow what I'm going to say? Because people aren't going to get it. If they want to remain cognitively dissonant, then they will. If they're going to say, well, the Cheeto in chief, the mango megalomaniac said that the Supreme Court didn't say it, then they didn't say it. Right? What's the point? Then I thought to myself, well, if just 10 people sees me read the Supreme Court ruling, and maybe half of them says, damn, you know, he's actually wrong. Now, I know I have sense. I know I have common sense, and my common sense is telling me that the Men in Black alien behind the couch, behind Pam Bondi and little Marco, said that the Supreme Court said, but that document right there didn't say what he said the Supreme Court said. I'm just saying, if I can get it in front of people and not read it in any unambiguous in any unambiguous terms, just read it, then I've done the work for at least 5 people. And the 10 who wants to just be there, then fine. Those are the deplorable few anyway. And I don't mind calling them deplorable, because if you can read the words and half the work is done for you because I downloaded it, I read it for you, all you had to do was listen. And the universe put me in your feed right there for me to read it for you. And I'm not illiterate. I don't have problems saying origins and confusing it for oranges. Whew. Just saying, call it out. Absolutely. Same shit that went on the Bush administration. Well, or they're afraid to get it. Hey, absolutely. I said that yesterday. Yes, maybe they are afraid to get it. Afraid of realizing that cognitively they've been dissonant. And what does it really mean? That they have to face the pride. That maybe you're not really a true Republican. Oh, what? You're not really a true Republican because you've come to your senses that maybe, I mean, he did look a little burnt orange this time, so maybe he baked too long. Maybe that's what it was. He baked it too long. Let me stop. Okay. And yes, clock it. Exactly. Clock that. But I mean, it's true. Shit. I mean, all right. Anyway, I got more for you. All right. Now, this gets good right here. Let me get on this side of the screen. This gets good because I got a video for you guys on what this is going to mean, because this is Judge Zennis basically saying, I ain't playing with you hoes. Because if this right here is not followed, trust me, somebody is entering into the contempt of court. But before we get there, let's go ahead and go to the next part. Shall we?
So already know Donald Trump is always pushing the lawless envelope. His latest criminal scheme that he just vomited out in the Oval Office and spewed into the public square? Sending American citizens to prisons in foreign lands. The problem is, he can't. Not lawfully. I know. But let's start with the new reporting. This from NBC News. Headline, obviously illegal. Experts pan Trump's plan to deport homegrown criminals. And that article begins, if an immigrant who the government claims is a gang member can be deported to El Salvador without any due process rights, then why not a U.S. citizen?
There we go.
That was the nightmarish scenario immigration advocates and constitutional law experts were considering on Monday after President Donald Trump again pushed the provocative plan.
Oh, I'm on y'all's ass, by the way. Okay, if in case y'all haven't figured this out, this whole State of the Union bullshit, it's about y'all. Okay, it's about all y'all who decided to vote for this Orangeman. Okay, it's all y'all. Okay, and mind you, again, I'm not really saying much. Okay, I got some documents, I got some articles. Okay, I'm gonna read to y'all the court documents. Okay, and I'm gonna let you, again, I'm gonna let you decide. That's all. I'm gonna let you decide based off of the law, United States Code, statutes. Let you decide. Because again, if this was the other side doing the same thing, there would be absolute mutiny. Hell, Obama wore a tan suit, and it was a problem. After this video right here, I'm going to talk about why this is a problem for Americans. It's not just about the fact of illegal immigrants or immigrants in general. There's a bigger fish at play here.
To deport U.S. citizens who have been convicted of unspecified crimes. Trump discussed the issue in the White House with El Salvadoran President Nayib Bukele, who has agreed to deposit people deported from the U.S. into a notorious prison. This from Trump, quote, we always have to obey the laws, but we also have homegrown criminals.
Obey the laws, right? Obey the laws. Hold on, stand by. Stand by. Because I do recall Chief Justice, I'm sorry, not Chief Justice, but Justice Sotomayor providing something called the United States Code. Stand by. Hold that thought. GovRegs. Here we go. What was that again? 8 USC. What was it again? Subsection 1, 2. Yep. 1226. Oh, you're gonna be a butt and not let me search it? Here. Try again. Oh, come on. 8 USC 1226. So let's get here. 8 USC 122. Here we go. Okay, so here and then 1. So I forgot to pull this up beforehand. 1226. Here we go. Take a brief moment. So 1226. And I don't believe in, not sharing things when I read things, because I don't want nobody to say that I'm, misrepresenting things. So here we go. So this is the law, okay? Apprehension and detention of aliens, by the way. And aliens are particularly unnaturalized immigrants, essentially. Okay? All right. And she cited A. So here we go. Arrest, detention, and release on a warrant issued by the Attorney General. An alien may be arrested and detained pending a decision on whether the alien is to be removed from the United States, except as provided in subsection C, and pending such decision, the Attorney General 1 may continue to detain the arrested alien, and 2 may release the alien on bond of at least $1,500 for with security approved by and containing conditions prescribed by the Attorney General, or conditional parole, but may not provide the alien with work authorization, including an employment authorized endorsement or other appropriate work permit, unless the alien is lawfully admitted for permanent residence or otherwise would, without regard to removal proceedings, be provided such authorization. It sounded like our guy Abrego Garcia qualified and was covered under this USC. But check it. Arrest, detention, and released on a warrant issued by the Attorney General. Hey, somebody ask Ms. Bondi if there was a warrant issued for all 200 and some odd people that was on those planes that Boasberg asked to be turned around. Something tells me the law was not followed here. Law and order president, right? Just saying. So many laws here. So many laws. And again, the law isn't saying that you can't apprehend or detain aliens. It's not saying that. But you can't do so by what? By what? Law and order. So befitting of a president who doesn't believe that he's supposed to follow the law in an orderly fashion. Cheerio. Carry on. Oh, wrong one.
Push people into subways, that hit elderly ladies on the back of the head with a baseball bat when they're not even looking, that are absolute monsters. Trump told reporters, I'd like to include them. Last week, White House Press Secretary Caroline Leavitt said Trump was interested in deporting heinous violent criminals who are U.S. citizens to El Salvador if there's a legal pathway to do that. During Monday's White House meeting, Trump said that Attorney General Pam Bondi is studying the law. Quote, it is pretty obviously illegal and unconstitutional, said Ilya Somin, a professor at George Mason University's Antonin Scalia Law School. Immigration law that gives the government the authority to deport people simply does not apply to U.S. citizens, noted Emma Winger, a lawyer at the American Immigration Council, a nonprofit advocacy group. Anthony Krice, a professor at Georgia State University College of Law, noted that the British policy of removing certain alleged criminals from colonies to be put on trial elsewhere was one of the grievances during the lead up to the American Revolution.
Now, y'all remember when I told y'all a long time ago that the Declaration of Independence was a good read? Remember that? I'll tell you, the Crown was interesting. I remember reading in the Declaration of Independence where the Crown had captured members of the colony, right? Captured one of them, or a few of them, and then made them go and off other members of the colonies on their behalf. Yeah. The Crown even went to the Indians and befriended the Indians and made the Indians, gave the Indians like inside information, and then had the Indians come and off and then go against the colonies. Oh yeah, the Crown was shrewd. How dare the Crown do that? But one of the grievances was the fact that the Crown was coming over to the colonies, grabbing colonizers, grabbing them, and then imprisoning them in other places, but also taking them and then taking them back to England for trial without cause, just because the Crown just felt like it, without due process. That is on the Declaration of Independence. How easily do we forget? Just carry on.
Quote, I can't see how exiling someone is permissible as part of the bundle of rights that are fundamental to citizenship. Doubly so if the effort to house American citizens overseas means turning a person over to a foreign authority, he said. David Vires, an immigration expert at the libertarian Cato Institute, said Trump's remarks show how absolutely critical it is for the courts to put an immediate stop to this extrajudicial imprisonment by foreign proxy. Quote, U.S. citizens may not be deported to imprisonment abroad. There is no authority for that in any U.S. law.
And just really quick, Black people, when they start imprisoning people overseas and shit, like England did its people, when they start sending people to Australia, for instance, because history is repeating itself, by the way. Hey, BMU, I hope you're here. where we gonna be at in line? Because my skin tone definitely tells me that I'm gonna be in the middle of a line. I'm just saying. And I have a strong knack to believe that the brothers of this network, irrespective to who you voted for, is not going to be in the back of the line. Play.
Added. So, friends, expert after expert and scholar after scholar make it crystal clear. You can't deport American citizens to foreign prisons. So, Attorney General Bondi, I know Donald Trump tells us that you're studying the law, but you might as well just go ahead and close that law book you're studying from. It's illegal. Now, I know what you're thinking, friends. Anytime you tell Donald Trump that he can't do something because it's illegal, he's likely to say, "Oh, really? Hold my Big Mac." So, friends, we know that the litigation in the Abrego Garcia wrongful deportation case is ongoing, and we know it will inevitably make its way back up to the Supreme Court. You may recall the first Supreme Court opinion in the case, although it was 9-0, was pretty mealy-mouthed, right? It said to the Trump administration, well, you're going to need to facilitate the release and return of Mr. Garcia, but the majority opinion hastened to add that, we don't want the courts to interfere in the Trump administration's authority to engage in foreign policy. Wait a minute. They unconstitutionally and unlawfully snatched up Mr. Garcia, stuffed him on a plane, and deported him to El Salvador, precisely where a judge had ordered the United States may not deport Mr. Garcia to. And all they have to do is send a plane there, tell the El Salvadoran president who we are paying to house Garcia. So we are, by extension, imprisoning Garcia down there because we're paying for it. We just have to say, give us Garcia back. We made a mistake. We've admitted in court we made a mistake, and Garcia is back in the United States. That ain't the practice of foreign policy. That's the executive branch making right what they did so desperately wrong in at least three
Your tax dollars at work, folks. I bet that's some of that $6 million money that Elonia Muskrat saved us, by the way. Pennies in a bucket compared to that $6 billion apparently he supposedly saved us, right?
Ways. But the Supreme Court opinion, mealy-mouthed as it was, indirect as it was, gives the Trump administration some wiggle room. Well, that will all come to an end when the case makes its way back up to the Supreme Court, which I suspect it will in the coming days. And then the Supreme Court needs to be definitive. You can't kidnap people and send them off to foreign lands and imprison them, pay to imprison them down there. Not immigrants who may be subject to deportation, because you first need to give them their constitutional due process rights of notice and opportunity to be heard so they can make their case.
And to be fair, this is what the 9-0 court said, and this is what the 6-4 court said, majority of the conservative court said. So again, due process and the fact that you need to bring this motherfucker back. Why? Because he was improperly sent over there. Now, as to the case of whether or not you can actually send somebody abroad, the Supreme Court has not necessarily ruled on that. That, to be fair, Supreme Court has not argued. As to whether or not the president can actually use the AEA, that the Supreme Court has not argued, to be fair. What the Supreme Court did say as to the AEA is that when you charge someone on any statute, that is under the guise of due process. Because in any court, whenever you charge somebody with something, due process comes in and says, okay, you're under the burden of proof to prove that someone is appropriately charged under a certain statute. Now, again, why am I arguing all this? Because I remember a time in America where our colored people, even if I am a little fairer skinned, I do remember when our colored people, even if it was just a drop, were not afforded due process. The part of the Constitution that protects the immigrant is the same amendment that protects you, whether you like it or not. Because it doesn't say certain people deserves due process. It says all persons. So if they can do it to one person, they can do it to all of us. And who do you think they're going to be doing it to next? Black people, they already can pull us out of our cars, put lead in our backs, and argue immunity and argue self-defense. Take off your blue jersey, take off your red jersey just for a moment and recognize the rare moment that the Supreme Court is actually arguing something that might not be for us, but it benefits us. Fuck the fact that it's against your orange God for just a moment. Damn the fact that we didn't hear as much as we heard this time about the last fucking administration. Fuck that. This is part of the fucking problem. Sorry, you put shit in my comments, and I'm gonna call this shit out. It's not about that right now. You literally have someone who, again, I called it out last week when I said that he was on Air Force One. He tinkered with the idea, and I said, start believing a motherfucker whenever they show you who the fuck they are. And every time I tell y'all to start believing somebody, it comes true. When y'all gonna start listening? Courts, irrespective to color or creed, are designed to, if litigated correctly, are designed to protect and rule on the law. That's why justice is blind. And this notion that only liberals rule partially and only conservatives rule impartially, that's some bullshit. 14 injunctions against Biden, and we didn't hear anything from the goddamn Republicans. Yeah, you have injunctions or TROs against this administration. Well, I wonder why. You're rounding up people. And look, just the just after the 6-4 ruling, Pam Bondi comes in and drops charges against someone of whom they do what? Of whom they decided to here we go. Doing this again. It doesn't let me again today. Here we go. Hold on. There we go. Uh-oh. Why is it being difficult? Here we go. DOJ, just 2 days after the 6-4 ruling, DOJ drops charges after charges against a man it labeled as an MS-13 leader. Well, I wonder why. It's kind of hard. It's kind of hard to prove. It's kind of hard to prove that somebody did something when you require due process, isn't it? Isn't it? Imagine that. I'm just saying, you be the, I don't know. You be the judge. Okay. So with that in mind, my point to you on that, and before we move on to the next part of this, is just this. You can choose not to believe me when we come around to the next cycle of voting, if you want. But he's literally rebuffing the Supreme Court. In my view, in my opinion, he's rebuffing the Supreme Court. After literally saying and suggesting that he would do what? Respect the Supreme Court. Oh, here we go. Right here. Hold on. Right here. Yesterday, President Trump confirmed that the United States Supreme Court has the power to facilitate Abrego Supreme Court's release from prison and return to the United States. If the Supreme Court said bring somebody back, I would do that. I respect the Supreme Court. Boom. Again, got receipts. Damn it, receipts. Of course, that is precisely what the Supreme Court did when it ruled that the court's injunction properly requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. The plaintiff filed this in court. When? Oh, 4/12. When was that? 4/12 was Saturday. Got to be more careful. Let's see. Get to the comments. Just thought maybe the reason the Trump administration are fighting against bringing him back is because maybe his soul is no longer in his body. Again, just thought that would be tragic. It's a possibility. And yes, it's a possibility that history is definitely repeating itself. Absolutely it is. So with that in mind, the Supreme Court, the administration is definitely going against the Supreme Court here. What happened, conservatives? So again, I said this before. If you're wanting to break this system, just admit it. Just come on out. Put the link in the chat. Come on out. I can do that. And just say that you voted for the system to break and that you want an authoritarian, you want a dictator, you want a kleptocracy, you want an oligarchical theocracy. Just say that that's what you want, but don't say that you want our system of government to work and then justify the opposite when the opposite comes into fruition and you didn't expect for it to. Don't do that. That's gaslighting, folks. Don't do that. Don't say, oh, he's supposed to rebuff the Supreme Court. Don't do that. Because then, of course, if the previous administration did that, it'd be a problem, now wouldn't it? Just saying. As we move on to the final bit of the media that I have for you tonight, because of course I got tabs on tabs and I never quite get to it because, as things start to go on, as again, I show you guys court documentation, and I could read the court documentation to you. But I have more for you to get to, because I got a surprise for you. So here we go.
United States Supreme Court ruled.
Oh, come on, I hate when it does that. Remove. Come on. Let's go.
Zinnis's order, and said that everything about her order related to.
Okay, really quick. Hang on. Okay, so Judge Zinnis, let's talk about her for just 1 second. So Judge Zinnis is the original district court judge that this whole thing started with. Not from 2019, but is the district court judge that ruled a injunction. Injunction against the administration, that the administration said, no, we don't like that. So then it went to an appellate court, and the appellate court agreed with the injunction, okay, against Abrego Garcia's deportation. And then the appellate court pushed it back down to the district court, and administration wasn't having that. So what did the administration do? They also tried to dismiss or to get her removed from the case as well, claiming jurisdiction. They wasn't having that because she has jurisdiction. So then what did they do? They pushed it up to the Supreme Court, and the Supreme Court gave her a 9-0 ruling. Unheard of. So now she is empowered. Oh, she is empowered. And now, that's your ass, Mr. Postman. Here we go.
To the facilitation requirement that the government facilitate Armando Abrego Garcia's removal and release from a El Salvadorian jail was proper, constitutional, and they affirmed it. They also said that everything she said about due process and constitutional rights as the requirement for the injunction are upheld. 9-0. It's all over. It's all over. Now it's just about what is the remedy for this illegal act by the government. The government has dug in and said, no, we don't agree with the Supreme Court's ruling. We don't agree with the language about facilitate. We think facilitate this is like a spelling bee. The government literally does not know what the word facilitate means. They've twisted it so out of proportion and contorted it. They want us to read that the Supreme Court affirmed that they only had to facilitate on the domestic side if Mr. Garcia at a port or at an airport, like he did his own prison break and just wandered in, that they would let him in. That's what they think facilitate is. But now they're doubling down after the White House press conference on Monday, and they're saying even if he were to present himself, they would let him in, but then deport and remove him to another country and revoke his status. That's in a brand new filing just before this hearing. I got two pieces of paper in front of me. I got a hot off the presses order of discovery by the judge, which is a prelude to a contempt finding, and a new filing by Mr. Mazzara, the acting general counsel of Homeland Security, in which he now says in paragraph 9, and this came up during the hearing and not in a good way for the Trump administration, I have been authorized to represent that if Abrego Garcia does present at a port of entry, like he just wanders in from El Salvador from a supermax prison, he would become subject to detention by DHS. Yeah, we get that. In that case, Department of Homeland Security would take him into custody in the U.S. and either remove him to a third country or terminate his withholding of removal because of his membership in MS-13, and as opposed to El Salvador. Okay. Now, the other problem the judge had today, before we get into the buckle up comment, from the reporting within the room, is that they tried to file just before the hearing at 4 o'clock a unofficial transcript of the Bukele of El Salvador, the petty dictator of El Salvador. You know, the guy with the black T-shirt and the suit jacket, like all petty dictators, when he was shoved into pitch and catch, a scripted call and response between him and Donald Trump, so they could use it in the into the United States. I will not do that. In fact, we have the clip. Let me show you the clip because it came up in court today. Let's roll the clip one more time.
How can I smuggle a terrorist into the United States? I don't have the power to return him to the United States.
So you can release him inside El Salvador?
Yeah, but I'm not releasing, I mean, we're not very fond of releasing terrorists into our country. I mean, we just turned the murder capital of the world into the safest country of the Western Hemisphere, and you want us to go back into the releasing criminals so we can go back to being the murder capital of the world? No, that's not going to happen.
Well, they'd love to have a criminal,
yeah, I mean, there's a fascination.
They would love it.
Yeah.
So back to me.
Now, really quick, I hate when people say that they would love to see the criminals released back into. Really drives me mad because I just read to you 8 USC 1226 that it provides that if evidence is provided and it leaves room for the judge to use discretion, correct? Right? Okay. So if the judge uses discretion based on whatever he or she determines, the judge can determine yay or nay and provide a work authorization or not, whatever the case may be. A judge can determine yay or nay. Based off of law, not just off of love for the people. So this isn't arbitrary. This is law and order. What am I missing here? Again, I just provided to you 8 USC subsection 1226 alpha through Bravo and Charlie. What am I missing? See, this is that disinformation portion. Yet again, where there are laws on our books that provide this level of discrepancy, or not this discrepancy, this level of discretion that judges can use. Now, if they don't want judges to use this level of discretion, then they shouldn't put it into the statute. But again, what's in the law is in the law. If you don't like it, change the law. But you can't go against it or criticize it. Change the law. There's a reason why there's the process, that there's a legislature. Where is the legislature in this process right now? Completely castrated at this point. I've never seen such a broken legislature until this man is in office. I'll end it there before I go on a rant about them.
Sorry. Drew Ensign, the lawyer who's arguing it, says, see, Judge, here's the official transcript. Here's, is it? And the judge says, that's not evidence. We're going to do this by the federal rules of civil procedure. I want sworn affidavits and declaration. Don't hand me some sort of transcript as a substitute for evidence. And I don't like the fact that I'm not being told what steps have been taken to get him out. Apparently, this is the judge now today at the hearing. No steps have been taken. I'm going to read to you from her order. No steps have been taken at all in violation of my order. In other words, she is just walking them into the trap. Just walking them into the trap. Let me read to you from some notes from people that were in the room today. When Drew Ensign pointed to the transcript, I got an unofficial transcript of the meeting with the President Bukele now. The judge said, first of all, you point to that, but we're doing this by the book, by the federal rules of civil procedure. She then went on to say, we're doing intensive 2-week discovery. I'm going to set a discovery order. The other side, Mr. Abrego Garcia's lawyers are going to get interrogatories, questions under oath have to be answered. They're going to get at least 3, if not more, depositions, all within the next couple of weeks. And if they need more, I'm going to give them more in support of their motion for contempt. She said, and I quote, I'll remind everyone here that there are no business hours. It will be 2 weeks of intense discovery. Once we have a record, take it from there. Right? Oh, and we'll take it from there. In other words, no PTO, no personal time off, and drop and give me constitutional compliance. When Drew Ensign started to argue about the Supreme Court decision, she said, they affirmed me in every way, shape, and form. We're only talking about a remedy now, and I'm not going to let you to relitigate. She said, if I made a finding of contempt, it'll be based on the record before me, and I don't consider this transcript given to me 15 minutes ago to be sufficient. The question is, she said to Drew Ensign, what have you done to facilitate his release and what to ensure that this case is handled as it would have been had he not been sent to El Salvador? She also reminded him that he's getting it wrong on the word facilitate, that the government routinely requests return of people wrongly removed, but there's no evidence that that had been done here. So she rejected entirely all of the positions that Drew Ensign for the government took about what the words in the 2-paragraph Supreme Court ruling means. Let me read to you from her order, which came off of the hearing transcript. Because when you hear these findings, you know that the Trump administration is about a minute before midnight getting nailed with a contempt finding. So here's what she says. This is on page 2 of her order. It is undisputed that Abrego Garcia is entitled to injunctive relief for the reasons previously discussed and affirmed by the Supreme Court without exception. And she said later in the hearing, every day that Mr. Abrego Garcia remains in that notorious Supermax prison is another day of irreparable harm. As to the scope of such relief, she continued, the Supreme Court of the United States unanimously affirmed that the district court, her order, properly requires the government to facilitate Abrego Garcia's release from custody. Not if he wanders around and shows up at a port or on a boat or at an airport. Released from custody in El Salvador, and to ensure that his case is handled as it would have been had it not been improperly sent to El Salvador. To that end, the Supreme Court forewarned that the government should be prepared to share to the judge what it can concerning the steps it has taken and the prospect of further steps. She then continues, this court, in turn, ordered no more than what the Supreme Court endorsed, that defendants take all available steps to facilitate the return of Abrego Garcia to the United States as soon as possible, because bound within this remedy is Abrego Garcia's release from custody and the assurance that Abrego Garcia's case is handled as it would have been had he not been improperly sent to El Salvador. To advance that remedy, the court required swift disclosure of that which stems most obviously from the Supreme Court's affirmance, the current physical location and custodial status of him, what steps, if any, the defendants have taken to facilitate his immediate return to the U.S., what additional steps they will take. This information is wholly consistent with ascertaining what, if anything, defendants have done to facilitate Abrego Garcia's release from custody in El Salvador. Notably, she then goes on to what facilitate means. Facilitate means to make the occurrence of something easier, to render it less difficult, quoting Merriam-Webster's dictionary. Instead, she says the defendants obliquely suggest that facilitate is limited to taking all available steps to remove any domestic obstacle. Return. The fallacy in the defendant's argument is twofold. First, in the immigration context, as it were, facilitating return of those wrongfully deported has and always has included more extensive governmental efforts endorsed in prior precedent. Second, and more fundamentally, she ruled, defendants appeared to have done nothing to aid in Abrego Garcia's release from custody and return to the United States. Based on that, she's ordering discovery. Now, some people might think, why didn't she find him in contempt? We're getting there. You got to make a record. The record's got to be airtight. The way that a federal judge does that, or a state court judge, is allows discovery. That's the gleaning of facts in an adversarial process through depositions, questions under oath in person, through on paper questions under oath, interrogatories, through requests for production. Then when she gets that record together, she'll do an evidentiary hearing in a week or two, or after the discovery is completed in the next 2 weeks. In the third week, she'll hold a hearing for contempt. And then she can make her ruling. We watched something similar with Judge Boasberg about the Alien Enemies Act. He just never got to the point of contempt hearing because the Supreme Court divested him of jurisdiction and sent the case off to individual judges in Texas. I don't see that happening here, given the Supreme Court ruling fully in favor of Judge Zinnes. Now, here's what she's ruled. By no later than Wednesday, April 16th, that's tomorrow, at 5 p.m., plaintiffs may create 15 interrogatories and 15 requests for production, 15 categories of documents sought, 15 questions under oath, and the defendant shall serve their response by Monday, a week from yesterday. Plaintiffs may also, by no later than Wednesday at 5 p.m., notice the depositions, right? Set the depositions for all the people that filed these screwy declarations in front of her that were violative of her order. That would be Robert Cerna, Michael Kozak, and this guy, Joe Mazzara, the general counsel of the Homeland Securities. And those depositions will get taken a week from tomorrow as a deadline. If no later than Wednesday, also by a week from Wednesday, the 23rd of April, plaintiffs may move to conduct 2 more depositions because they may pick up names from the people that they're deposing. That's why the judge said at the top of this hearing, buckle up, intensive discovery. I don't believe your argument. I don't believe your argument about what facilitate means. And every day you file something, I'm not relieving you of your obligation for 5 p.m. filings every day. Every day is, basically in her mind, is another version of contempt, another act of contempt, but she needs to develop this record. Once the conclusion of the expedited discovery happens, she set an outer boundary of Monday, April 28th. So 2 weeks from now, plaintiffs shall then supplement their motion for relief. Remember, the plaintiffs already filed a motion for contempt. She's asking them, once you get all the discovery in the record, to supplement it with whatever you get out of these people on the Trump side and bring it back to me. And then gave the Trump side until Wednesday, April 30th to respond. Once the court has all of that, then the court will hold a hearing. In the meantime, the court will hold in abeyance, will sit on for a moment the other remaining requests that the plaintiff made, find them in contempt, amend her order to give them specific instructions. She's going to wait until expedited discovery and supplemental briefing is done. That said, she ends the order this way. Should defendants, the Trump administration, fail or refuse to engage in the above described discovery in good faith, plaintiffs are free to seek separate sanctions on an expedited basis. Drop down and give me constitutional compliance. This is Drill Sergeant Zinnes. That's every federal judge I've ever been in front of. And I'm glad to see she's remained in this case trying to administer justice. We got some breaking.
All right. So, look. All right. So here is the ruling that he was reading from here. And come on, you guys know I was going to find it. All right. And look, she goes down the line as to, and look, the fourth part, the burden on the government is minimal, particularly because the Supreme Court underscored it should be prepared to share what it can concerning the steps it has taken and the prospect of further steps. The Supreme Court made it very clear that it should be prepared. It should be prepared to take additional steps from her. So there is no, there isn't going to be in any of this mindset of taking it to the appellate court, taking it to the Supreme Court, and getting any relief from them, because the Supreme Court made it very clear. Get him back and follow up with this clarification of what effectuate is. And she just basically took out the word effectuate and just took facilitate. That was a follow-up order the same day as the 9-0 ruling. And up until this point, they've basically defied. defied her orders. So what is she doing now? Baiting them, giving them the rope to essentially hang themselves, essentially is what she's doing. And good on her for doing so. Because again, I have to suggest, and I have to see this come through for fact check, and absolutely, that's what I do. So with that in mind, I have to say, and sometimes you got to read the actual footnotes too. The footnotes have some interesting tea in it too. But oh wait, I saw the United States Marshals in there. Okay, that's an example of where the United States Marshals did something similar. Hold on. Would you please scroll up? Thank you. One second. It's a part I wanted to go up because he read something else. In here that I wanted to get to. Right here. So as to the scope of such relief, the Supreme Court of the United States unanimously affirmed that the district court's order properly requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Right here, folks. So just in case you missed it, right there. To that end, the Supreme Court forewarned the government that they should be prepared to do these things. Again, we're going to highlight that for the people in the back. Okay? All right. And it is fair to read the district court's order as one required that the government facilitate Abrego Garcia's release rather than demand it. So here we go. Now, onward to my surprise. Because y'all thought that, I'm just going to be honest with you. Oh, one thing. In case y'all think that a court or a judge can't rule contempt filings against an administration, you'd be wrong. You'd be dead wrong. And there is a mechanism for which a judge, any federal judge, can rule contempt filings, and it can be criminal contempt filings against anybody in the administration. There is a mechanism for that within the United States Code. And if I have to, we'll go over that next week. Okay? You'd be shocked as to how they're able to rule contempt filings and imprison people by using mechanisms within the executive branch. Okay? The judicial branch is not powerless, by the way. So y'all thought, and I thought as well, that Judge Boasberg was done. He's not. Cue in this. Boasberg comes back with a bang. Now, the only reason there we go, I'm back. Now, the reason why I'm a little bit elated about this is because I'm a little shocked. And I'm gonna let my man over here from Legal AF talk about this just a little bit, because he does a little bit more justice than I do, because I'm not a legal scholar, okay? Even though I know how to look through the CFR, the United States Code, and so on and so forth, and look up these things. But given the sake of time, and this is a 46-page filing today. So I got this right off the fucking presses today. All right. So here is the Judge Boasberg finds probable cause to hold Trump administration in criminal contempt. Okay. So I saw this article and I was like, yo, what? And then like right after that, here comes the hot takes. Okay. So essentially, I'm going to go down to the bottom. Okay. Because it's a long read, y'all. It is a long read. Okay. Yes, I read it, but it's a long read. Okay. So yes, breaking news, bitch. Breaking news. All right. Listen. So for the foregoing reasons, the court will find probable cause that the defendant's actions constitute contempt. It will provide them with an opportunity to purge such contempt. Okay. If they opt not to do so, the court will proceed with to identify the contemnors, there we go, and refer the matter for prosecution. Remember, I told you there's a way for the judiciary to get your ass if need be. A separate order so stating will issue this day. Now, remember in the previous clip I showed you where basically Judge Boasberg's cases was basically split off into Texas for the most part, which those cases are already on the docket already in Texas. I found it in the litigation tracker already. I'm already tracking them. I'm already on it. Boasberg, for the most part, is basically saying this. I'm gonna play the clip, but basically what's happening is Boasberg is saying, now, y'all, I had a TRO. I had an injunction. And here's how injunctions work. You see, you have to do what I say up and until the injunction is stayed. You can't avoid, you can't obfuscate doing what I said do in the injunction just because you think it's going to get stayed. So because you ignored what I said do up until it was stayed, y'all fucked around and y'all about to find out. So this is back to them not turning them damn planes around. Now, let's be fair for a second, shall we? Say I was in the court of law and I decided to ignore or go against a court order, even though the court order was eventually overturned, but I still ignored the court order prior to it being overturned. Does that still make me liable? Yes, it does. Because it's still in effect up and until the time that it is overturned. That's like saying that a law is in effect until it is repealed. Let's hear the lawyer break it down for you.
Startling news. Not only do we have the first ruling by a judge finding the Trump administration in criminal contempt of court by Chief Judge Boasberg, district court judge in D.C. about the Trump administration violating his temporary restraining order by continuing to fly planes over his injunction to ground those planes to El Salvador under the exercise of the Alien Enemies Act. We have the criminal contempt order and even a threat by the judge that if the Trump administration does not immediately intend to return those prisoners on those two planes that were sent to El Salvador and bring them back to the United States to purge their contempt, that the judge wants to know from the Trump administration the names of all the people that violated his order, because he's going to send them, he's going to make a referral for criminal prosecution. Now, some might be thinking, well, there's a limit there because the criminal prosecution part's in the executive branch. Not so fast. I think there's a way for the judge to appoint his own prosecutor to go after the Trump administration if they don't do it themselves. I'm Michael Popak. You're on the Midas Touch Network. We're breathless for a reason on this one. There's been a lot of threats. There's been a lot of people in the Midas Mighty and Legal AFers that have been demanding a contempt finding by a judge for the willful, defiant disobedience of the Trump administration. This is now probably the fourth or fifth version. We're watching it play out. where they're not obeying the Obregon Garcia ruling by the United States Supreme Court. But this has to do with 2 plane loads of people who were deported and removed to El Salvador in that same prison, but over the injunction of the federal judge. And the federal judge says, and I'm going to read to you from his orders today. He says, you might be thinking, how can I continue to exercise jurisdiction since the United States Supreme Court vacated my order on a technicality or found that it had an error in it? In other words, the Supreme Court said, well, we get your point. And they do need due process, but they really need due process in the form of a habeas corpus petition that should be done before they're loaded onto the planes in due process wherever they are in the United States. The Supreme Court basically letting 250 other people rot in an El Salvadoran prison, but saying, well, going forward in the future, if you're, as long as you're still here, you get due process. You get it by way of writ of habeas corpus, not in a class action with Judge Boasberg, not in the District of Columbia, but in Texas. But the judge says, yeah, that may be true. But until my order was reversed, it was effective, and you violated it. And no man, no matter how high or exalted his station, can make his own judgment about whether he's going to obey a judge's order or not and say, well, I think it's going to be overturned one day, so I'm not going to do it. You can't crap over the Constitution. I'm translating it for you. Let's get to the order. Now, the judge had a choice. Most judges in kind of a progressive discipline for somebody that's in contempt will find them in civil contempt. But the facts here are so bad and egregious against the Trump administration, this judge skipped the civil contempt, went right to criminal contempt and the threat of putting people in jail if by next week these people don't come back from El Salvador. And you know the Trump administration is not going to bring people back from El Salvador because they're laughing and mocking federal courts and the Supreme Court right now over Obregon Garcia. So we know where this goes, and so the judge does too. Because if they don't bring people back by next Wednesday, then the judge wants the names. He's taking names and he's kicking butt. Who are the people that violate?
I mean, if you are going to be so egregious, so feckless, then take the Hillary Clinton approach and just do it behind closed doors. At the very least. Don't be so cavalier with it. Like, damn. I mean, I don't know. Just that's another topic.
Violated my order. I want the names on my desk by 5 o'clock next Wednesday. And then from there, he's going to make that referral for prosecution. And I'll dive into that as well. Speaking of diving, let's get into the judge's order. And it really starts at the very beginning. I'm going to read you a little from the beginning, a little from the middle, and a lot from the end. Here's what the judge says. On the evening of Saturday, March 15, 2025, this court issued a written temporary restraining order barring the government from transferring certain individuals into foreign custody pursuant to the Alien Enemies Act. At the time the order issued, those individuals were on planes being flown overseas, having been spirited out of the United States by the government before they can vindicate.
Not Spirit Airlines. Sorry, I'm not going to laugh at this one.
Their due process rights by contesting their removability in federal court. Rather than comply with the court's order, the government continued the hurried removal operation. Early on Sunday morning, hours after the order issued, it transferred 2 plane loads of passengers protected by the TRO, temporary restraining order, into a Salvadoran mega prison. The court...
I think the judge got some inside information somewhere. I think somebody leaked the information, and I think he got what he needed to get. My theory.
Ultimately determines that the government's actions on that day demonstrate a willful disregard for its order, sufficient for the court to conclude that probable cause exists to find the government in criminal contempt. That's extraordinary. Extraordinary. No, I don't think any other presidency, other administration has ever been found in criminal contempt of violating a court order, maybe during the civil rights era. The court does not reach such conclusion lightly or hastily. Indeed, it has given defendants ample opportunity to rectify or explain their actions. None of their responses have been satisfactory. Then the judge addresses, well, my order was vacated. Does that take away my jurisdiction to find people in contempt for violating the order before it was vacated? He answers the question, no. When the world inevitably goes downhill, which, let's be honest, it's not looking.
Oops, I forgot to clip that out of there. There we go.
Answers not just how this compliance inquiry can proceed, but why it must. The rule, the judge continues, reflects a belief that in the fair administration of justice, no man can be the judge in his own case, no matter how exalted his station or righteous his motives. The Constitution does not tolerate willful disobedience of judicial orders. especially by officials of a coordinate branch, co-equal branch, who have a sworn an oath to uphold it. Otherwise, it would be a solemn mockery of the Constitution itself, citing United States versus Peters from the first Chief Justice Marshall in 1809.
Oh my God!
He then goes off
into history, Jack.
on page 14 and says the following. Defendants provide no convincing reason to avoid the conclusion that appears obvious from the above factual recitation. They deliberately flouted this court's written order and separately its oral command, because he did it at a hearing as well, that explicitly delineated what compliance entailed. They do not dispute that it was hours after the written order issued that they disembarked the class members aboard two planes and transferred them out of U.S. custody.
Hold on. Stand by 1 second. Do not, hang on, dispute. Stand by. Remove. 1 second. I told you I got the T. They do not dispute that it was hours after the written order was issued when they disembarked the class members aboard the two planes and transferred them out of U.S. custody. Rather than offer a mea culpa and attempt to explain the grave error and detail plans to rectify it, defendants offer various imaginative arguments for why they nevertheless technically complied with the order. So, did I just read that basically they just admitted to their defiance? So again, I'm a law and order president. We're going to get back to law and order. So much law and order. We're going to have, I'm a Donny boy. We're going to have law and order. So much law. We're going to be winning with law and order. Right? Right? Interesting.
Rather than offer a mea culpa, the judge continues on page 15, and attempt to explain this grave error and detail plans to rectify it, defendants offer various imaginative arguments for why they technically complied. None of their positions withstand scrutiny. So here's his order. Let me unpack it for you here. This is on the last page, on page 46. The court finds probable cause that defendant's actions constitute contempt. We know that's criminal contempt. It has the opportunity to purge that contempt. If they opt to do so, if they opt not to do so, the court will proceed to identify the contemptors, the people who actually did the contempt, and refer the matter for prosecution. Now, here's what the minute order along with this says. Given the finding of probable cause for contempt, the court orders that defendants, if they opt to purge, they do so by April 23rd with a declaration explaining the steps they have taken and will take to do so, to bring those people back. If defendants opt not to purge, then they need to identify those people with knowledge of the court's class-wide temporary restraining order who made the decision not to halt the transfer of the class members out of U.S. custody on March 15th and 16th. Now, what can the judge do after a referral to the prosecutors? Because you know Pam Bondi's not going to continue this case. They're not going to take this case, not going to prosecute people in her own executive branch. Then the judge has a choice. He does have the power, based on my analysis of case law, to appoint his own special prosecutor if the government found in contempt will not follow through with it. He can appoint a special prosecutor from the state side or from somebody who'll take the case. I can think of a few attorneys general, maybe like Letitia James, make them a deputized special prosecutor to prosecute those people in contempt. And that's what I would encourage the judge to do. This judge has people in high places. I know that Donald Trump's going to run off to the Supreme Court. Kavanaugh was his roommate in law school. Justice Roberts likes him a lot. He's considered to be one of the most esteemed federal judges on the bench, despite what Donald Trump is saying today about him being a liberal, wacko, activist, criminal, corrupt, and all the rest of it. He's none of those things, and the Supreme Court knows it. And now they're going to have to decide whether they're going to back a federal judge enforcing his powers, having found on the record probable cause that criminal contempt was committed by this administration.
That's what I'm talking about. That's what America wants. Nice and calm. You're almost there. Don't mess this. Oh no!
That's what America wants. She. That's what America wants. I have another theory. U.S. Marshals. At any rate, what do y'all think? Okay. Put it in the comments. Either here now or later on. Okay. After the show concludes. All right. Like I said, filled your belly full of law tonight. Okay. But from the judge's perspective. Okay. Not so much from the United States Code tonight, but from what the judges ruled. Okay. Because yes, and these are conservative. Well, one of them was a what you would consider a liberal judge, and the other one is a conservative judge, and then you have a 9-0 ruling, 6 of which conservatives, and I'm sorry, no, not 6. Excuse me, I'm sorry. Yeah, I said it right. Yeah, 6 of which are conservatives and 3 are liberals. So majority conservative. See, I'm even more than fair on a largely conservative network. Damn. Come on.
Little, you got to be able to pume.
I did it fair. I gave it more from y'all's perspective based on the color of creed that the judges were, even though that really honestly shouldn't matter. Who appointed the judges should not matter here is the point. In my conclusion, that really shouldn't matter. Because in any case where the opposing side admits to fault, let's put it like this. Here's another test. If it was your case, and if you're still watching this, or if you will watch this later, or if you decide to clip it, if it was your case, and your freedom was on the line, and the prosecutorial side admits to fault, and it means the difference between your incarceration or your freedom, wouldn't you want the state or the federal government to heal? I bet you would. And that is what I'm arguing here tonight, is that the government should heal and take the L. Because what it wants to do ultimately is ignore law in a disorderly fashion, ignore the Constitution at the end of the day. And my question here is, if you think that's correct, why? Why would you ever think that's okay? What part of you thinks that would be okay for America? And if you do think that's okay for America, then I have another question for you. Say whatever type of country that establishes law or rule of law that you may like. What's to stop it? What's to stop it from doing the same exact thing. Wouldn't you want that new country, that new creed to be upheld? And would you not want that vicious cycle to repeat itself? I have questions. What bothers me is that, and something I've heard recently, is that what could be fixed with surgical precision is being bludgeoned with a sledgehammer, or bludgeoned with a demo ball at this point. And y'all voted for it. Whoever you may be. And I'm here to tell you that it's okay to say that you bit off more than you could chew. It's okay. It's okay. It's okay to say, you know, that orange is starting to stain up too many walls in my house. It's okay. I didn't intend for him to ignore. I didn't intend for him to remind me of times when we Black people were having our rights completely ignored. Okay? Because do believe and best believe that when it comes to the first people in line after what you guys call the second-class citizens, who some do deserve due process and some don't deserve due process, we're next, whether you believe it or not. So you can choose not to believe me all you want, but it wasn't that long ago, just less than 60 or 70 years ago, that we were on a chopping block, or just right on the edge of a tree's branch. Wasn't that long ago. How quickly do we forget? Anyway, hope you guys enjoyed the show. Hope that it was informational and not disinformational, not DIS, but DYS, informational. Anyway, please make sure you support the show. Please like, share, and subscribe. Make sure you do comment, okay? Stay informed, all right? Read for the love of God, okay? Whatever God you believe in, okay? And whatever higher power you believe in, please read, stay informed, okay? And think objectively, all right? Be objective. Be willing to adjust your mindset. Get out of the belief, and maybe you would turn away from the lie that's within the belief, okay? Because as I showed you earlier, they will tell you something you should believe. The truth should come easy. It's the belief that they want to tell you and feed you a lie in order for you to believe the belief. Okay? So with that in mind, be objective. All right? And stand on that shit. Okay? Good night, everybody. Salute to